video is to explain the prior use exemption from Section 119 of the Patents Act. Section 119 states, "A person may, without infringing a patent, do an act that exploits a product, method or process and would infringe the patent apart from this subsection if immediately before the priority date of the relevant claim the person A. was exploiting the product, method or process in the patent area, or B. had taken definite steps, contractually or otherwise, to exploit the product, method or process." Confusing? Hang on, let's break it down a little bit. So as a defence to a claim of patent infringement, this section allows a person to continue to exploit a product, method or process in that patent area if immediately before the priority date that person was using it or had taken definite steps to exploit it. So what does exploit a product or process mean? In this case, it means to actually make, hire or sell a product or offer to do so, as well as use a method or process. This includes importation and storage with the intention to sell. Priority date is defined as the date when the initial patent application, either provisional or complete, for an invention was submitted. This means that a party using or relying on an unpatented product or process before another party patents an invention of the same kind is able to escape infringement and continue using their product or process. The principle of law that this exemption is promoting was outlined in the Jupiter's case as a third party cannot be prevented from continuing to do what they were doing prior to the grant of a patent. So how is the exemption applied and who can use it? When an action in patent infringement is firstly established, then the defendant may use the prior use exemption as a full defence to the claim if successfully proven. The defendant must provide evidence of their exploitation of the product or process and that it occurred prior to the patenting of the other invention. Or the defendant must provide evidence for the definite steps taken to exploit the product when the product is not yet in use or being sold, but there has been a reliance on the exploitation of it. Once established, the prior use exemption can be assigned over to another, such as when a business is sold. However, it's not able to be licensed. Case law applies definite steps to mean that the preparations for exploitation are so advanced that the infringing act would immediately follow. So when can't this exemption be used? A defendant is not protected under this exemption when there has been non-continuous use or exploitation of the product or process. This narrows the scope of the defence to ensure that a balance between the rights of the patentee and the fair user is met. Also, this exemption does not apply when the defendant has derived their product or process from the invention of the patentee, except in the case that the patentee has made the information publicly available. It also can't be used when the prior use has occurred outside of Australia. So in summary, the prior use exemption of the Patents Act allows legitimate parties' rights to be protected when faced with a future patent in the same area of product or process. The rights protected are to avoid being liable for patent infringement, to continue using and benefiting from the existing product or process, and to assign the exemption to another legitimate party. This law is important to balance the patentee's rights with the protection required for other parties.